Welcome back to Empire Law. I'm Abby, and today I'm here with Deborah Song from Empire Law. Good to have you back, Deborah. Thanks for being here today.
Thanks for having me again.
Today, we are covering one of the most complete pictures of car accident law you will find anywhere in the Inland Empire. We are breaking down both sides of the equation, the types of crashes that happen on I-10, I-15, and the surface streets across San Bernardino County and Riverside County, and the types of injuries those crashes cause, and how both of those things directly determine what someone's compensation claim is worth. The crash type determines who is at fault. The injury type determines how much. If you have been in a crash anywhere in the IE, this episode is for you. The IE sees some of the heaviest commuter and freight traffic in Southern California, and certain crash types come up over and over. What are the most common types of car accidents in the Inland Empire that actually lead to compensation claims?
Yeah, so the most common types that we usually see day in and day out are going to be your typical rear end collisions, your intersection T-bone crashes, head-on collisions. We have multi-vehicle pileups, truck and freight accidents, and then hit and runs as well. Those are probably the most common car crashes that we see around here.
And rear end crashes happen every single day on IE freeways, especially during the LA commute. Most people assume the person who hit them from behind is automatically at fault. But when someone gets rear-ended on an Inland Empire freeway, how does that usually affect their chances of getting compensation?
Rear end are typically the easier ones because there's what's called in California a presumption of fault. For when you are rear-ended, the trailing driver, so the person that rear-ended you, is presumed to be at fault under the California Vehicle Code, and they have a duty to maintain a safe distance and following distance behind you. So the burden gets shifted to them to prove something else happened. But it's not always automatic. There are situations, like I said, if the person that rear-ended you can fall under one of these exceptions and prove one of these exceptions. For example, if you, let's say, brake checked the person that was tailgating you or following behind you due to road rage or something like that, and the person behind you that ended up rear-ending you as a result of it can prove that you did brake check them. Or sometimes there's situations where I hear this actually quite often, which is not, it's harder to believe, but sometimes it could happen. I'll hear that the other driver is claiming that they backed into the car in the front, backed into the car in the back. So our client would be the car that got rear-ended, but then the person that did the rear-ending is claiming that our client is the one that backed into them. It's usually harder to believe something like that. I've seen it actually happen one time where there was a person who was driving a manual stick shift. And usually with those manual stick shifts, if you don't use your clutches and your brakes properly and timely, it can go into this neutral phase where it starts to back up. So there are situations where something like that could happen as well.
And then head-on collisions are some of the most dangerous type of crash on the road, and the Insurance Institute for Highway Safety consistently reports they produce the most severe injuries and highest fatality rates. Why do head-on collisions on Inland Empire roads often produce the largest compensation claims?
Easy rule of thumb it's funny because I usually tell clients this too. You never want a large compensation because that usually means something bad happened. But in a head-on collision, it's a huge force of impact compared to like a rear ender on a low speed. These people are going towards each other as opposed to, let's say, following one another around the same speed and same momentum. When they're going towards one another, it gets crashed and collides right in the center, and it comes basically to a complete stop. So essentially, it's like running into a wall, right? Running into a pole, running into a still object. That's the kind of impact that head-on collisions create. And usually in those situations, the way airbags are designed in vehicles, the airbags are designed to deploy when you do have a head-on collision. And the airbags itself, even though they are designed to protect you, can actually cause injuries as well. The way it inflates is it takes your gas that's in your gas tank and it fills up that bag to pop it up like a parachute, and it hits you in the face. So it's hot air. So sometimes people can get burns from that as well. And when your airbags do deploy and the amount of force going from, like, let's say 40 or 80 miles per hour to zero, it causes you to have whiplash and it causes your body to be thrown around. And especially if you get thrown forward when you're head on colliding, your body gets thrown towards the point of impact first. So if you get hit in the front, your body will go to the front and the airbag will deploy, then it sends you back. And so you get this a lot of movement in your head and hitting lots of parts inside of the vehicle with your body, and your body's very fragile. So it results in a lot of traumatic brain injuries, damage to the spinal cord. I've seen clients who have internal organ injuries. I've seen one with the seatbelt. It locks in because that's what cars are designed to do to prevent you from getting further injuries. It'll lock you in. But when you're being forced to stay back, that part where the seatbelt is, it does push you back, just that area. But all the other areas that are not being protected and held back by the seatbelt actually kind of come forward. And so with that movement, part of your body is being pushed back and part of your body is being flung forward at the same time. And it can cause that kind of an impact can cause necrosis or death of tissue in that abdomen area. So I've seen that as well. But yeah, it's just usually the force of impact that causes a lot of the high damage claims. And then as long as you can prove, and that's the other thing, head-on collisions, there's a situation with liability. So if you're in a head-on colliding situation, that usually indicates somebody went to oncoming traffic. It's kind of hard to prove if there's no cameras. And that's why I always tell my clients to have dash cams. Usually people that's been involved in accidents once will have a dash cam after that. Because it's really hard to prove who went over whose lane and caused the head-on collision unless they're truthful and honest and report it that way to the police and the insurance companies. Because you're going to say they went into your lane and then they're going to say, no, you went into their lane and caused the head-on collision. But if you can prove it and you have all the evidence to prove it, then for sure, high damage along with high probability of proving liability equals a large compensation claim.
I had no idea that's how that airbags worked. That's really interesting. So intersections across the IE, especially the older signal-controlled crossings in San Bernardino, Riverside, Ontario, and Rancho Cucamonga, generate a huge number of crashes. At Inland Empire intersections, T-bone accidents happen a lot. How do lawyers and insurers determine who's responsible in those cases? I know you just mentioned it's hard to prove, so how do you guys determine who's responsible in those cases?
So we go through quite a bit of different routes. Whatever route we feel like we can go through. Usually in situations like this, we let the client know we are going to look into how to prove that they had the green light. Usually that's the situation with T-bone accidents. It's who had the red light, who had the green light, who was supposed to stop, who didn't stop. But one of the first things that you look for is pulling up Google Maps and asking the client, okay, what intersection are we at? Where are we looking? Where are you coming from? What's on your left? What's on your right? So then I can put myself in that Google Map point of view and see, okay, this is what you're looking at. This is your light. And if you actually see on the Google Maps, you can see what kind of light it is. If it is a red light, green light situation, you can look at it and see, okay, if our client had to turn left, let's say, it's usually that's presumed to be kind of like in a rear end situation, the rear ender is presumed to be at fault. If it's a left turn straight situation, the person turning left is presumed to be at fault, because whoever is going straight is considered to be part of the natural flow of traffic, and whoever is turning left is known to be the person or the object on the road that's causing a change and shift in the traffic pattern. So whoever is causing the change and the shift in the traffic pattern is the one who has the duty to be careful and make sure that you're going when it's time for you to go. But let's say you do have to turn left, and one of the first things I look for is the light. And if I see that the light is solid red, solid yellow, solid green for that left turn for our client, then I know that our client, even if it was green, it wasn't a protected green. And when I say protected green, that means a left turn arrow. So in a situation where it's a solid green, in California, you need to stop in the intersection, wait for all the cars to go by, and then after all the cars have gone by, because they usually have a green light too, because usually if yours is a solid green, then the people on oncoming traffic going straight is also a solid green. So wait for all those cars to come by, then you can turn. Now, if it's a protected green, meaning it's a situation where the left turn light is an arrow, then it makes me feel more confident that we can somehow, if we can get some video footage, if that's one of the other things I do is I turn the Google Maps around in that intersection and see if there's any local gas stations, any supermarkets, churches. Sometimes it could be like a residential area and the residentials may have Ring cameras. If it's a situation like that, then I would be like, okay, our client has a better chance of proving that if he had a green light, then it was a protected green. Because when it's a protected green, meaning it's a left turn green arrow, that means for sure the other side, whenever there's a left turn green arrow on our side, the other side, oncoming traffic must be red. There's no way that they could have a green light. So in that situation, we will look to see if there's any cameras. That has to be done within 7 days, because any kind of businesses or residential communities that have these cloud-based or even hardware-based recording systems, they loop over because the memory is limited. So usually it's not like a set in stone, this is the way it is, because every device is different. But most devices, it's around 7 days. So within that 7 days, I would send out a private investigator to go try and collect that footage from the community nearby, if there is. If there is no video and the client does not have dash cam and it's just red light, green light, solid, and there's just no way to prove that our client had a green light and it was safe for them to go. The other option is something called EDR. I don't know off the top of my head what it stands for, but these EDR readings, so every vehicle has what's called a black box, and this black box, if you hire an expert, which costs a lot of money, so to save our clients money, usually what I do is I'll call our client's insurance company, because our clients' insurance company usually have the resources and the experts already on payroll to go ahead and pull that EDR footage basically for free. And so we would ask our client's insurance company, hey, can you pull the EDR data, the raw data from our client's black box? And so hopefully you still have the car. Hopefully the car's not totaled and it hasn't been salvaged and sent out to the junkyard or whatever. But if your car is not totaled and your car is somewhere in the tow yard or at home, the first party, your insurance company, can send somebody out to collect that information. And in that black box, it shows a bunch of data. It includes things like, did our client have their seatbelt on? What was the speed the car was driving at the time of the accident? How slow was our client going? Was our client's foot on the accelerator or the brake? Things of that nature. So with all that data that you pull, and the force of impact. So how hard did the other vehicle hit our client or how hard did our client hit the other vehicle. And with that information, it can actually be helpful. So in situations like that, let's say our client was the one that turned left. Let's say we are able to get our insurance company to not only pull the black box data, the EDR data from our own client's vehicle, but they, under the investigation, was able to also collect that information from the other vehicle. A lot of times that might show, let's say that the guy that was going straight on that red light, it will show that guy was, even if it wasn't on a red light, it's not going to show a video, it's not going to show a red light, green light, but it can capture the speed. Because a lot of times what happens is a lot of these people, when they're trying to punch through the red light, when the light is yellow, they're like, oh, I better speed up. And sometimes they blow through red lights, and that'll capture how fast they were going. And if there were any signs of trying to stop and brace for impact or brace for the accident. So lots of information can come out of that, and we would hire experts to analyze that information and tell us what that means and what the cars were doing and who stopped first and who didn't stop. And that would work out as well on stop sign situations. Even though it's not a red light, green light, it will indicate who came to a complete stop, how fast the car was going. So let's say it was like 50 miles per hour in the intersection. There's no way, if it's a four-way stop sign, there's no way someone's going to go from 0 to 50 with halfway through an intersection after coming to a complete stop. So things like that can help prove liability.
Wow, that is really insightful about the black box. So the IE freeway system funnels enormous traffic volumes through a few corridors, and that creates pileup prone conditions that you don't see in most regions. Multi-car pileups, rollovers, hit and runs, each create unique challenges. How do compensation claims work in those situations in the Inland Empire?
So starting with the multi-vehicle pileups, compensation, the first question I would ask, if I had a new client that called us and was like, hey, I was involved in a freeway accident and it was a 5-car pileup or whatever, I would first ask my client, which car were you? Numbering from 1, 2, 3, 4, 5, from the front to the back or the back to the front, doesn't matter. Just which car were you? So then I can picture in my head, okay, this is the situation that our client is in. So let's say our client is the one in the very front. It's the car in the very front in the 5-car pileup. Then my second question that I would probably ask is, how many impacts did you feel? And the reason why that question is so important is because a lot of times in these 5-car pileups, they like to easily, kind of like the presumption of the rear end we were talking about earlier. When somebody gets rear-ended, usually the person that does the rear ending is presumed to be at fault. In a situation like this, where it's a 5-car pileup, it's presumed that the car in the very back is the one that caused the rear ending domino effect. So it's like the car in the very back, the pushed, and then hit our client's car. But if that's the case, that means our client in the very front should have only felt one impact, because the car in the very back, let's say, hits the car in front of it, then that 4th car hits the 3rd car, then the 3rd car hits the 2nd car. The only time our client feels any kind of impact from this accident would be because the 2nd car hit our client's car. Now, if it's a situation where our client felt more than one impact, sometimes our client can feel 2 impacts. And if the client felt 2 impacts and the client is in the very front, that tells me that that the 2nd car behind our client's car hit our client at some point before the car got pushed into our client again. So it doesn't necessarily mean that the car right behind our client is the one that hit our client first, because there is a possibility that car number 3 or car number 4 could have been the ones that caused the rear ending to the 2nd car to then hit our client, and then the car in the very back hit and did the domino effect again and hit our client twice. But at least it shows that there are two insurance policies in effect. So however many impacts you feel, you can think about it that way. However many impacts you feel, you should be able to collect on that many insurance policies. And then depending on, usually in situations like that, a police will show up and do a report because there's just so many cars involved. And after he gets everybody's statements, usually the police report will let you know like who the cop put at fault. And there's situations where the officers will put the guy in the very back because, like, let's say people don't really know about this stuff. So they all assume it's just the guy in the back, I don't know. And they end up hitting it. Regardless of that situation, even if the police says like, oh yeah, it was the guy in the very back that pushed into everybody, at least we know we have that guy. But if our client felt more than one impact, then there is some other person in the middle that we have to figure out. It's much easier if it's a 3-car pile up and the client felt 2 impacts, because then that'll tell me that the car behind our client hit our client first, and then the car in the back hit the second car, which then pushed that car into our client again. And in situations like that, then you can collect on both insurance policies. For rollover accidents, rollovers typically, when I hear that we have a client that had a rollover situation, my first red flag that I think of is that the person who rolled over, if that's our client, probably overcorrected the situation. So there's situations where a client will try to avoid an accident because somebody is doing something negligently. Let's say the guy is coming into our client's lane, our client freaks out and turns the handle. And when you turn it in a very abrupt way, when you're traveling high speeds, that usually that steering, that momentum is what causes a car to roll over. So that's typically a situation where I will probably see a disputed liability, meaning the other side will claim, especially if they didn't even hit the car. If the other driver did the unsafe lane change and try to merge into you or something like that, but didn't even hit you, then it kind of looks like you just did this whole thing on your own. You just rolled over. So in situations like that, I can see the other driver saying, no, this is not my fault. Sure, I may have come into your lane, but after I realized you were there, I went back into my lane, and whatever happened after, that's on you. But if the injuries are severe enough, it might be worth the fight. And that is something you have to think about as well when you are thinking about pursuing a claim. Is it going to be worth it if we're going to go to litigation? Although that's a completely different topic. But yeah, usually these rollover accidents, they cause a lot of injuries because it's not a typical rear ender. You're getting hit multiple times in different directions. Usually you're hit from the side, then the car rolls over to the top, and then it rolls over to the other side. Sometimes it ends up back upright, but that's like 4 accidents in one. You can think about it that way. And I'm sure every airbag at that point would have been deployed from the front, from the left, from the right, from behind you. And so you're getting hit in all different directions. So that's that. And then I think hit and run accidents. Number one thing with compensation claims for hit and run accidents is call the police and file a report within 24 hours. Because when you try to get compensation, so in a hit and run situation, if you cannot end up finding the other guy, that means you're left with your own insurance company trying to take care of you. And then after your own insurance company takes care of you, they do further investigation to find that guy or girl, find that person, the other driver, and get reimbursement for all that your insurance company has paid you for this claim because it was that person's fault. But let's say you do want to go through your own insurance. And this is why it's also very important to go through your coverages. Don't always look for the cheapest premiums because that's not protecting anybody. It's just the insurance company taking your money, and then when the time comes where you actually need it, they're like, oh, you don't have that, you don't have this, you don't have that, can't do anything for you. But if you have what's called uninsured motorist coverage, then in a situation like that where the car hits and runs and it's unidentifiable, that person that ran away, they're considered as not being insured in the insurance world because they are an unknown person with an unknown insurance. Even if they did have insurance, because they were not able to be identified, they are by default considered uninsured. And if that person is uninsured and you make an uninsured motorist claim under your own policy, if you have that coverage, some of these insurance companies, I know Mercury specifically, but some of these insurance companies, including Mercury, has a paragraph in the policy when you purchase the premium that when you want to open up an uninsured motorist claim, you must file a police report within 24 hours. And the reason why they created this rule is because they don't want people causing accidents on their own to claim for injuries or claim for damages and basically do insurance fraud, pretend that an accident happened when it didn't. So their thought process is, if you called the police and the police came out and did an investigation, more likely than not, it's a real legitimate claim that you didn't just make up. Because if somebody was just making up an accident on their own and they just backed up into their wall or whatever it may be, then those people probably wouldn't call the police because they don't want the police to find out that they committed insurance fraud. So in situations like that, if you do want to get compensated, please make sure to call the police. And once you do, then at that point, you can call the insurance company, your insurance company, open up the claim and let them know you had called the police, you filed a report, and give them the report number. Then you should be able to get the compensation that you deserve.
And most states follow some version of comparative negligence, and the rules vary depending on where you live. California's rule is one of the most plaintiff-friendly in the country, but most people don't know how it works. So how does California's pure comparative negligence rule affect the compensation someone can recover in an Inland Empire crash?
So in 1975, there was this case in California. It's called Lee versus Yellow Cab Company. And out of that case came a new rule that the judge created because it wasn't an issue that was litigated before. And it was a case that eventually went to trial, and for the first time, a judge ruled on it. And basically what rule came out of that case was that even if our client, even if the person that was injured from the car accident was mostly at fault, they are still entitled to some compensation. So in our world, in California, in the legal world, we call that pure comparative negligence. It's pure. So the way the damages are calculated is on a pure percentage ratio of your at fault. So if, let's say, your claim is worth $100, okay, then you are 99% at fault. That means you still are entitled to 1% in compensation. So out of that $100 claim, you're still entitled to $1. If you were in another state and the accident happened, I can't think of I think Alabama might be one. I can't think of them off the top of my head, but there's other states that don't follow this pure comparative fault. There's some states that say you have to prove that you are only 49% at fault or less. So you have to mostly be not at fault to be able to recover. Even if you're 50-50, you're not able to recover half of your damages. Huge. Like in California, let's say you are 50% at fault, you can still cover half of whatever compensation it is that you are seeking. So I think that's pretty nice here in California. You're able to obtain whatever percentage of damages you are entitled to, even if it means it's only $1. You have the right to seek that and you have the right to fight for it. Now, let's say insurance companies' job in California, because we have that kind of rule, insurance companies, their job is to increase the liability percentage on you as much as possible. So making that number of liability higher on you means less recovery for you. And that's why it's always important to have a dash cam. If it's not too late, if you're watching this before you get into an accident, just get the dash cam, then you don't have to worry about anything. But if you are watching this after the fact, then yes, you have to be very careful about what you say, because any little word that you say, they can utilize that and say, oh, okay, here, I'll add another percent. Or, oh, I can use that to argue that you are partially at fault because you volunteered some information that you didn't really need to say. You were just being nice and you were just volunteering information. But yeah, in situations like that where you feel like you may be put partially at fault or fully at fault, sometimes a client will get a heads up based on their interaction with the other driver. If the other driver comes out of the car and they're very combative or they're defensive or they're upset and they're saying you're at fault, then it's a cue that they're going to say something to the insurance company that may not be true. So it's always easier to just call an attorney and have them open up the claim for you. So even if you are partially at fault, the words that are being said are not only truthful, but also putting you in the best light, putting your best foot forward in the situation that you're in. And ultimately, if your case does go to trial, it's going to be the jury that puts that percentage on you. So going to trial is a gamble, but if an attorney is willing to take your case, most likely that means they are willing to take that gamble. So if you go to trial, the jury will be given what's called a special verdict form, and that special verdict form will have an instruction and it will have a question presented to them saying how much percentage at fault is the plaintiff, how much percentage at fault is the defendant, things of that nature. So the jury will fill that in. And then below that, there will also be questions about damages, or sometimes above it. It depends on the attorney and how they want to arrange it. But the jury will say how much pain and suffering, how much medical bills, how much lost wages, and all that gets added up. Then whatever is on that plaintiff percentage, that gets multiplied by the amount of damages, and that's the amount that you would win if your case made it all the way to trial and verdict.
All right, we have covered the crash types, rear end collisions, head on crashes, T-bone accidents, pileups, rollovers, hit and runs, and how California's pure comparative negligence rule changes the math on every one of them. So now here is the other side of the equation, the type of injury you actually suffered and how that drives what your case is worth. So we're going to go into section 2, injury types, and how they drive compensation value. So whiplash, we've talked about it a little bit, is what most people think of after a car accident, especially the rear end crashes that happen all day on IE freeways. But there is a perception problem with these claims. So how do soft tissue injuries like whiplash affect car accident compensation claims in California?
It's funny because soft tissue is actually verbiage that insurance companies use, and they utilize that to put a minimal value on your claim. Never in my career, in my history, have I ever said our client has soft tissue injuries, because number one, you don't know that. And number two, it's saying that it's soft tissue already puts a general, I would say, lower end value on a claim. And it's funny because the adjusters, when I say adjusters, they're the person that's assigned to your claim in that insurance company. So let's say you have a case with X insurance company and you have a claim number. There's a person handling that claim number, and that person is called an adjuster. So when that adjuster calls us to get updates on injuries, a lot of firms actually will just say, oh, the client's still treating, and they don't really give them any information. They think it's bad to give information, but it's actually really good because they have to set what's called reserves. So when an adjuster asks you, what is your current treatment status? What are you up to? What are your injuries? what are you doing nowadays as far as treatment goes? You never want to just be vague and be like, oh yeah, I'm still treating, because that doesn't tell the adjuster anything, because most of the time they label it as soft tissue right off the bat. Unless it's something very horrific, the damages are pretty, your car's totaled, it rolled over, it was a head-on collision. Unless it's situations like that, most likely they automatically put it starting off as soft tissue. So if you don't give them information otherwise, they're going to continue to say it's a soft tissue, meaning it's just muscular, it's surface level, it's not very deep, it's not that serious, is essentially what they're trying to say. And so when they call us to tell us and they say, oh, it's soft tissue, I don't know why your client's still treating, they don't know that. So the only way to find out the severity of the injury is going to be to watch them and watch the clients and see what kind of treatments they do. A lot of times, if you end up going to see a chiropractor, and I say a chiropractor, I know there's like a lot of negative connotations with chiropractors, but the good thing about chiropractors when it comes to personal injury claims is that they usually know how to work with the insurance companies. And so unlike your health insurance providers, like your primary care physicians that are limited to what your health insurance can provide within an X period of time and all the approvals and the red tape that they have to go through and you having to go through all those bridges. The good thing with the chiropractors is they have the medical degree to order images, to order studies. They can't order any prescriptions, they're not medical doctors, but they can refer you out to see a specialist, kind of like a primary doctor would, but it's nicer because it's not through your health insurance. It's through, usually it's called a lien, and I don't want to get too much into that, but they will be able to send you off if they suspect that you may have a spinal injury, which is what will refute the claim that it is a soft tissue injury, is they'll usually order an MRI. And this MRI, what it can show, as opposed to x-rays, because if you go to an urgent care, you go to the ER, you go to the primary doctor, more likely than not, they're just going to order x-rays, which is good to show if you have a fracture or not. But most of the time, the clients aren't having broken bones from, let's say, a simple rear end collision, but they are having pain. And the way to look for that pain is depending on your symptoms and what kind of injuries you're experiencing and the pain that you're experiencing, the chiropractor orders an MRI, and that'll show the damages in your disc, not just the bones like an x-ray, but there's discs and there's nerves all around your spine and in between each vertebrae. And so it'll show what kind of details and structure your spine looks like. And depending on which level and the size of a disc and how swollen it is or what nerve it's touching, it can actually coincide with what you've been complaining of. So if, let's say, you're complaining of X pain, if the doctor orders the MRI and looks at the MRI and sees that you have a disc bulge that's touching on the thecal sac or a nerve root at the X level, and that level is, and that nerve is connected to that area of your body that's having that pain or the numbness or the tingling, then it's objective proof that your pain and your injuries are not just surface level. It's not just soft tissue. It's not just muscle damage. It's further than that. It's deeper than that. It's inside your spine, which at that point is now considered, at least in my opinion, it's considered a serious injury. It's a spinal injury. So yeah, soft tissue is, I think, a terminology that insurance companies like to use, but I would never use it because we just don't know.
And then there's the other side of the spectrum on severity that is catastrophic. The Brain Injury Association of America reports that TBIs are one of the leading causes of disability in the United States. And then the National Spinal Cord Injury Statistics Center estimates that the lifetime care costs for spinal cord injuries can exceed $5 million. So, how do traumatic brain injuries and spinal cord injuries impact compensation and litigation timelines?
This one's actually interesting, and I don't know how much of it I'm actually supposed to go into, but these injury claims and the way the insurance companies view each claim kind of changes with time. And it's funny because traumatic brain injury is actually the newer trend these days. And I say a trend because they've always existed, but they've never added value. And I don't know if it's because now even things like mental health and going to therapy and seeking counseling, things of that nature is becoming a lot more normal. And studying the brain in general and cognitive deficits, there's just more technology to that, even though a lot of it is subjective in the sense that if you have a brain MRI and you have a traumatic brain injury, if it's not a severe one, most of the time you don't detect much. So I feel like 99% of the times I've had clients with traumatic brain injury symptoms like neurocognitive deficits, dizziness, blurry vision, loss of appetite, sleeping too much or not sleeping at all, finding themselves misplacing items in strange spots that they've never used to, putting keys in the fridge, things of that nature. And a lot of times clients, they don't think about it, they don't associate it. And that's why it's very important to talk to an attorney first, because the first thing they think of is just pain. They think of their neck, they think of their back. But unless you talk to an attorney who has experience in traumatic brain injuries, they can ask you questions and you're like, you know what, I have, but I had no idea that was possibly even related to the accident. Ringing in the ears, you have that, a high pitch ringing in the ears, any kind of symptoms like that. But yeah, so nowadays that's trending more, it's becoming more acceptable in the insurance world. And because it's your brain, I think that's what's causing it to have such high claim value, is because you are your brain essentially. Without your brain and your fully functioning neurocognitive assets, you lose who you are. And so a lot of times, not a lot of times actually, sometimes in a worst case scenario, even though it's not traumatic in the sense that, because sometimes some people think traumatic brain injuries can be only situations where you're paraplegic or you become a vegetable or now you can't walk or you can't talk, like an after effect of having a stroke or something like that. But there's high functioning people with traumatic brain injuries from even a whiplash, even a rear end, simple rear ender. And that's why I don't, like we were talking about earlier, I don't like to say soft tissue because you just never know. But anyways, so in situations like that, we have a high functioning person. There was one time we had a client who was an attorney, and being an attorney, especially if you are a trial attorney, you have to be able to think quickly off your feet. So she was very scared to lose her job after this car accident because her faculties weren't as sharp as they used to be. And so even though for everyday people she looks fine and she looks normal and she's going about her day, the way the brain injury affected her at work, she was foggy, she wasn't able to think quickly. And because if you're not able to think and act quickly in situations where the adversary is saying things are coming out of their mouths or things are coming out of the witness's mouth, and you need to be able to combat that right away, you miss that chance and you can blow a case like that. And technically that's legal malpractice. So because of things like that, if you lose your income, if you lose your job and you can no longer be an attorney, and now you have to either do something that's less than what you were doing, even if you're still an attorney, you can't be a trial attorney. Let's say you're still an attorney, but maybe you just do paperwork. That is a huge difference from where you're coming from. It's going from very high functioning, very high paced, going at, let's say 200% to down to 100 or even 75. It's a very life-changing situation. And so, yeah, it does add a lot of value to the claim. In situations like that, you think about it, maybe even $5 million is not enough. If a trial attorney could make that in a couple years, let's say, and they're no longer a trial attorney and now they have to work for 10 years or 20 years to make the same amount of money, it's a lot of it's a lot of income that they lose. And I've had people who were married, and because of the brain injury, when you sustain a brain injury, a lot of times it's very frustrating because you want to say something. Sometimes that happens. You lose your ability to find your speech, and what you're trying to say, it doesn't come out. So it's called word search. So you're searching for these words and you're trying to answer the question. You're having trouble processing information coming in. People are asking you questions and you're trying to figure out, what did they ask me? And then you're trying to figure out what words you can use, and it becomes really frustrating. And to live that lifestyle every day and then not being able to sleep or feeling groggy all the time, it really affects the way you are emotionally. And so a lot of times we'll have clients who become snappy, who become very short, and it causes a lot of tension in their relationship with their spouse. And I've actually had one client that ended up having to get divorced. And so in a situation like that, coming from a loving marriage with children, and then now because of this car accident, you end up in a divorce and losing your child, losing custody of your child, because let's say the husband had to, or the wife, the spouse, had to call the police on you because you became violent due to a burst of emotions that you were feeling in relation to the traumatic brain injury. Now you've lost custody of your child. So in situations like that, you hear 5 million, it's okay, but you lost your life, your whole lifestyle, and your family. So that's the reason why traumatic brain injuries, they can cause a lot of disability to the patients. And that's the reason why the claims are so high.
Yeah, thank you for explaining that so in depth for us. That definitely sounds very severe. So let's get into the broken bones and internal injuries that are some of the most common injuries in car accidents, especially in the high-speed freeway crashes that can take place on I-10 and I-15. So when someone suffers broken bones or internal injuries, how does that affect compensation calculations?
Calculations, I would say, so for example, we were talking about earlier, the insurance companies, they like to put your injuries by default into soft tissue world. An exception to that rule is if you have a broken bone. So if you're in that soft tissue world, let's say that means they're anticipating your case is going to be worth no more than $10,000, let's say. But if you have a broken bone, that's no more soft tissue. It's not a surface level. It's by clearly imaging x-rays. It's deeper than the muscle. It's deeper than just the tissue. It's a broken bone. So it automatically puts you in a different tier when it comes to compensation. And how much that is, it will depend on each insurance company of what they categorize that as. But more likely than not, if you end up getting hurt by a common person that's driving a car around the 10 freeway or the 15 freeway, somewhere around Loma Linda or anywhere in the IE, they're not driving around with more than $100,000 worth of coverage. So if you have an ER visit, most likely, I think Loma Linda is kind of like on the higher end. So let's say your ER bill's around $40,000. That's already half of, let's say, the $100,000 policy. That's possibly, and even the 100,000, it's a lot. It's like on the high end of what people carry around here. On the low end, which is the most common that people do carry around here, is the California minimum, which is around $30,000. That's the California minimum that people are at least required to have if they're driving around the world, driving around the roads here in California. You're required to have at least $30,000 worth of liability coverage. And a lot of people in this community, they do look for the cheapest premium, and that means that they're carrying the cheapest policy. So if that's the situation, as far as compensation goes, it's pretty quick. Because if you have a $40,000 bill at the ER and the other driver only has $30,000, it's a pretty easy pop. You might not even need an attorney for something like that. I would say as long as the attorney is being truthful and they're not trying to just take your money, if you tell them, hey, this is the insurance company I'm dealing with. Because some insurance companies, just based off the name of the insurance companies, the attorneys know how much they're carrying. So if they are honest about it, then they would be like, hey, you don't need me, just submit the bill. You'll be able to get compensation on your own.
And then let's talk about burns, disfigurement, and psychological trauma that represent some of the most life-altering consequences of a car accident. The American Burn Association classifies burn severity from first to fourth degree, and the American Psychological Association has published research showing that PTSD and anxiety disorders are common after serious crashes. How are these injuries evaluated in compensation claims?
Anytime you have a visible injury, it adds to the value of the claim. So one of the first questions I will ask if a client is calling is, I would say, hey, if you haven't done so already, go look at a full-size mirror, go get butt naked. If you have somebody at home, see if they can examine your backside, see if you have any bruises. Sometimes it's on the head and the back of the head when you hit the headrest, things of that nature. But any kind of bruising or cuts, let's say from the seatbelt, burn injuries, usually from the airbags, if the car is exploded and then the car is what caused the burns, that would be a little bit more obvious. But let's say if there's anything like that, you would want to take a picture. There's times where clients, they're not thinking about insurance claims, and of course they're not. People don't think about it like we do, and they just think about getting an attorney later when they're feeling a little bit better. And by that time, let's say the bruise is gone and there's nothing documenting it. So it that can also affect it. We can say that you had a bruise. If you went to an urgent care, it's also nice because they'll label it as a contusion and they'll notate that you have a contusion, which indicates that you have a bruise. But seeing a picture of it, a visible image of it, is a value driver. And then if it's permanent, let's say it's a scarring, a lot of times that happens with dog bites. If you get bit by a dog and the bite was deep enough, even after it heals, it leaves, depending on the person, some people suffer from keloids, and it can actually create keloids. It can create scarring. It can create hyperpigmentation. It can create discoloration. And in situations like that, we have our clients go to therapy, like scar revision therapy. They'll usually do chemical peels, or they'll do, now you have to live with that every day of your life. And you have to see that, witness that, be reminded of that incident, whatever it may be, every day. And it's even worse if you are, let's say, somebody who makes money off of your own image, especially if it's like your face. A lot of females more so than males, because let's say you have a burn and it's like in the back of somebody's knee. A guy may not have a lot of pain and suffering attached to that. Some guys are into that. Like, I know I have some motorcycle clients who totally like scarring because they think it's cool. But a lot of women, let's say, or even models, they make money off of their image. If they have disfigurement, which is what permanent visible injuries are, like burns, scarring, if they have that disfigurement element, that could actually be associated with lost wages. Let's say now you can't get your jobs anymore. You used to be a beauty model, and now your face has a burn or it has a scar. You had to get stitches, whatever it may be, and nobody wants to hire you anymore. So that can cause a higher value in the compensation claims. And then some people, especially after the dog bites, they do end up suffering from PTSD, ending up having to see a therapist. Worst case scenario, they end up seeing a psychiatrist. I think I've seen some clients who got a lot of help from seeing the psychiatrist. I feel like for the most part, on top of the medication, is more so temporary, hopefully. Hopefully it's not permanent. But it's just to kind of help you get re-exposed to that trauma element, whatever it may be, whether it be dogs or whether it be driving on the freeway. It will kind of keep your nerves down. Usually it'll be like anti-anxiety type of medication, and they'll have you on that, and then they'll tell you to do some exercises with the dogs, or they'll have you do exercises where you're driving a little bit on the freeway, and then you have that exposure effect until it fully recovers. And of course, if you never recover and you're never able to drive on the freeway again, or you had to stay away from dogs and you're deathly afraid of dogs now, and you had to give away your own dog, things of that nature, all those little aspects of how it affects your daily life adds value to your case, your overall case.
All right, we have covered both sides of the equation now, the crash types that create liability and the injury types that drive compensation value. Now let's talk about the mechanics that connect them: medical evidence, expert testimony, treatment timelines, and how all of it shapes what the case is ultimately worth in the Inland Empire. So we keep coming back to medical evidence. The American Medical Association has guidelines on how expert testimony should be used in personal injury cases, and in complex cases, the right expert can make or break the claim. What role do medical experts play when determining compensation for serious accident injuries?
When it comes to serious accidents, there's different kinds of experts that can come into play. The first one you run into, and this is all in litigation. So this is after a lawsuit has been filed because the insurance company wouldn't pay, or they're paying too little, or whatever it may be, we end up having to sue. So after we file the lawsuit, and we go through a process called discovery. And the idea behind this process called discovery is both sides get to discover what each other has as far as evidence goes. It's show me your cards and I'll show you mine. So we get to see what each other has, and then come to a determination on how strong their case is, and they get to evaluate and do the same thing on our end. Now, the first expert that you usually run into, if your client is seriously injured, most likely than not, that means you have a long-term permanent injury that's continuous. It's not something that has resolved. And in litigation, if your injuries are still remaining and it's continuous and it's still active, that will give the other side an opportunity to say, hey, he or she, this client, is complaining of X, Y, and Z. Frankly, and they'll never say it like this, but basically what they're saying is, I don't believe them. I don't believe that they are that seriously injured. So because I don't believe them, I want to, and this is the other side speaking, I want to hire my own doctor to examine this client and come to his own or her own opinion about the injuries and the current state of them. And that's what we call an independent medical examination, an IME. In our world, in the plaintiff's world, where we usually are the ones doing the suing, asking for compensations, we call those DMEs as opposed to IMEs, as defense medical examinations, because that's what it is. It's a doctor that's hired by the other side. And these doctors, they're recycled. It's always the same doctors, and they all get hired to say the same stuff anyway. But they'll hire this doctor, and then your client will go over there. Usually we'll send a nurse with the client to make sure that the other doctor's not doing anything shady and pretending to do examinations and claiming to do these things when they're actually not doing it, or they're doing it incorrectly. So they go and they get examined by this doctor. Now, this doctor usually ends up being one of their experts later on if the case ends up going to trial. They end up being one of the doctors that testify as to, I saw this client on such and such date, and after my physical examination and review of his medical records, I've come to the opinion that these injuries don't need as much treatment as the plaintiff is claiming. Or sometimes they'll say things like, this client who is seriously injured will not live as long as the plaintiff is claiming. And that's the more hurtful part, is they want to cut the damages based off of the client's going to die soon anyway. But those are one of the experts that the other side will hire. And their job is to basically go to trial and testify to try to cut the damages of our client's injuries, to minimize it and lower it as much as possible. And then another expert that both sides will typically hire. So the other side will have one. Our client on our end, we will have one as well. It's a plaintiff's life care planner and then a defendant's life care planner. And these life care planners, like we were talking about earlier, if it's a serious long-term injury, you want to be able to calculate how much money is going to go into taking care of this person for the rest of their life until they die. Because when you go to trial and you're asking for money, you have to ask for everything all at once. It's not like you can ask for up until now and then come back again later and ask for some more. So you have to get everything that you want out of that jury right then and there. And so these life care planners, their job is to plan that client's life care for the remainder of their life. And so a lot of the fight between the experts become, well, how long is the life time of this person based off of these injuries? If you're this paraplegic or if you're this much a vegetable, then by science, by physics, by biology, you have a shorter lifespan compared to a healthy adult at the same age or something like that. So our life care planner will obviously say our client's going to live forever as long as we can by what's medically possible. And then the other side will say, oh no, they're not going to live that long. And then also the care, there will be a dispute on what is necessary. So our life care planner will throw everything that's could be considered as necessary. Let's say stay-at-home nurse, or physical therapy every day, or things of that nature. And then the other side might say, this guy's going to be a vegetable. They don't need any physical therapy. It's not going to help at all. So let's cut that out. They don't need an in-home nurse. You can put them in a, not a hospice, but like a assisted living situation. It'll be much cheaper, things of that nature. So there will be battles on things like that when it comes to life care planners. There's other experts too, vocational rehab specialists. So vocational rehab experts, these are like a physical therapist in the serious injury world. So you know how in physical therapy, they'll do exercises with you to try to get your mobility back. But in vocational rehab, when it comes to serious injuries, usually it's a brain injury, they will lose their ability to speak. It's not just like muscle stiffness, they just can't walk anymore. They've had damage to their spine. They've lost their ability to process, to do thought processes, and to turn that into words and actually communicate that with others properly. They lose their ability to function and utilize their limbs in the way they voluntarily want to. So these vocational rehab specialists, these experts, both sides will also hire them each. We have our own expert. The other side will have their vocational rehab expert, and they'll be saying different things. And ultimately, the vocational rehab experts will say, this person can recover with this much treatment, or they'll say, this person, even if they do all their therapy and all their rehabilitation exercises, they will only be able to reach this much percentage of recovery, and then they will never be able to go back to the way they were, which also adds value to the claim. Different experts, but at the end of the day, these experts go to the trial, our experts, their experts, and they go on the stand and they tell the jury their opinions about our client's situation and how much they're going to need and care, how long they're going to live, things of that nature, what they are capable of doing, how much recovery they're capable of having. And then the jury does what they want to do with it, depending on the expert. And it's very important which expert you end up choosing, because sometimes, let's say that the expert is like really smart, right? And they came from Harvard or something like that. Usually the other side will have like really people with very good credentials, because they can afford them. And so sometimes that can actually backfire, because you have to think about who this information and who this expert is talking to. And they're talking to a jury of usually 12 lay people from that community. So in this situation, it would be like San Bernardino County, Riverside County. They're usually talking to people that live in this community. So having somebody talking out of their butt with using language they use from Harvard is not very effective. So you have to have an expert that's able to really explain it in a way that the jury can understand and absorb, because then the jury can say, okay, I believe this expert, I understand what they're saying. And the more they can understand, the more it helps your case, because then they can write that down. Juries love to write things down, so they'll write it down. They'll be like, okay, this expert is saying XYZ. That expert, I don't know what he's saying. So things like that. So there's a lot of play when it comes to experts and how it can make or break a case, based off of how they testify, what they know, and what they testify to the jury.
Amazing. Thank you for explaining all of that. It seems like there is a lot that can be said for all of these different factors that go into a case. So medical records are the backbone of almost every car accident compensation claim. Without them, the insurance company has no reason to pay. How do medical records and documentation gaps affect the outcome of compensation claims in California?
So medical records and the words that are used inside those medical records is what helps to establish a direct link between the accident and the injuries. It's what we call in our world causation. So it's not enough just to say that you are hurt, the accident happened. We must also prove that the injuries and the hurt that you are experiencing is because of the accident and not something else. And the insurance companies, they like to look for these red flags that can possibly notate that whatever you're experiencing is from something other than the accident. Because if they can prove that, then they don't have to pay. So these are going to be things like missing medical records. So let's say sometimes I have situations where clients, they go see somebody they found off the newspaper, they do treatment out of their house. The problem with going to places like that is, even though you say that you went there and you paid cash or Zelle or whatever it may be, when it comes down to it, most of these people, that even though they may be effective and they may actually really work and do treat you well, if they don't have any medical records, it's as if it didn't happen. Your bills and your statements showing that you paid somebody can be helpful, just to help fill in that gap. It'll show that, okay, you did go, but it's not as helpful when it comes to trying to prove, why did you go? What did you tell the doctor? What did the doctor do, if they don't have any medical records? The other thing is delayed treatment sometimes. And a lot of the times it's usually because clients think that the pain will go away on its own. Nobody wants to make a big deal after an accident. They just think, okay, I'll just take some Tylenol, go to sleep, and hopefully it'll be gone. But the longer you wait for these symptoms to disappear, by the time you realize it's not disappearing and you decide to go to treatment, you go to the urgent care or the chiropractor or the primary doctor, whoever, it may be too late. Too late in the insurance world sense, not in your medical treatment sense. It's never too late to get medical treatment. But when it comes to the insurance world, now you have a gap, whether it be 1 week, 1 month, hopefully not 1 year, but whatever that gap may be, now the insurance company has that much question mark room to say what happened during this time. Maybe you went to the gym, maybe you were in the middle of moving, maybe you fell down the stairs, maybe it was something else, you slipped in the shower. anything. It leaves a question mark, a lot of room for question marks. And if there's any room for uncertainty, the insurance companies will hone in on it. So it's always better, even though it can be a pain in the butt to go to urgent care and sit there and wait. And especially because you know they're not going to help you anyway, because they just give you pain pills and then tell you to go follow up with your primary doctor. But the sooner you can document those symptoms by a medical doctor or a healthcare professional, it's more helpful when it comes to your claim.
Then this is a concept that most people outside of personal injury law have never heard of, but it is one of the most important milestones in any car accident claim in California. The American Medical Association defines the criteria. What is maximum medical improvement, and why does it matter so much in compensation claims?
So maximum medical improvement, I actually don't like to utilize that in our world. I think we use that more when it comes to like workers' compensation to have a permanent disability rating on a particular client to say that the client has reached maximum medical improvement, meaning the client is no longer going to be able to improve on their symptoms anymore. They've hit their max when it comes to their medical treatment, and their capability of being able to improve on those symptoms has plateaued. I don't use that too much when it comes to our end. We don't like to say that the client has plateaued unless it's like a serious injury. If it is a serious injury, and that's when the life care planner comes and they have to decide what's your long-term care plan. If it's like a normal everyday person with not a paraplegic or vegetable major TBI situation, then usually I like to always make sure that our client has hope for recovery. But if the client does have hope for recovery and the injuries are permanent, that is a sad situation, because then, yes, you have to bring in a life care planner to calculate what kind of treatment you now need, even though you've reached the maximum improvement. And that's actually how the other side will fight your case, is they'll say you've reached maximum improvement, so you don't need any more treatment. And so that can actually hurt your case too. So I don't tend to use that too much. But it does help when it comes to pain and suffering. If you can no longer improve, sometimes I have situations like that where a client, he needs shoulder surgery. He got a tear in his shoulder from a car accident, and he physically, biologically is not able to. He cannot get medical clearance due to the condition of his heart. So now, I guess in that sense, it's a maximum medical improvement because he cannot do the surgery he needs to get better because of his heart condition. So now he has to suffer with that for the rest of his life, because there's no way that he can fix it without dying on the operating table. So that can definitely increase the value of the claim, because now your pain and suffering is prolonged due to inability to get the improvement that you need.
And then the medical bills are one side of the equation, but the income someone loses during recovery and potentially for the rest of their career can be even larger. We touched on this a little bit earlier in the episode, but the Bureau of Labor Statistics publishes data on average earnings by occupation, and the Social Security Administration has its own disability determination process. So how do lost wages, future income losses, and permanent disabilities affect compensation in serious California injury cases?
So wage loss from the date of the accident up until, let's say, the present day, or up until the day you're supposed to retire. So it'll be different than a life care planner where they're calculating your care for the rest of your life. In a lost wage situation, they're calculating your wage loss up until you're supposed to retire, whether that be 65 or whatever that may be, based off of your occupation, what people in that occupation typically, what age they retire at. It's usually calculated using pay stubs or tax returns, any kind of proof of income. It becomes a little bit harder if you've just started a new business or something like that, because then your calculation of your lost wages is up in the air. It's a question mark. It can be what's considered speculative, that you're just speculating what money you could have lost if you don't have much history backing up how much you've made from that in the past. And then if you have a permanent disability in California, they have what's called a multiplier. And the reasoning behind that is because the permanent status of it allows you to recover all the way up until the lifetime of the person who has been injured. And there's no cap. There's no cap in California when it comes to the personal injury auto cases. Lost wages and future earning capacity, you can recover that at full value.
So we have covered the injuries, medical evidence, and the financial impact. Now, in the next section, we're going to bring it all together with the practical side and how insurance companies calculate settlements, when to hire a lawyer, what happens at trial in IE courts, and what to do if your claim gets denied. So this is where a lot of frustration comes in. The insurance company makes an offer and the victim thinks it's insultingly low, but there is a method behind how adjusters calculate settlements. The National Association of Insurance Commissioners publishes guidelines, and the Insurance Information Institute tracks average settlement ranges. California insurance companies calculate settlement offers using a specific process. Can you explain how it actually works?
Yeah, so different insurance companies use different kind of software, but in general, the calculation that the insurance companies use is they'll take a look at your medical bills and they'll take a look at your lost wages. They'll add it together and then they will multiply that by anywhere between 1 and 5 to get your general damages, meaning your pain and suffering damages. So if your bills are low, the way their thought process is you had little treatment. And if you had little treatment, you're not really in pain or suffering that much. So because they're doing it based off of that correlation, it's sad, but the more bills you have, it'll show them that the more treatment you have, and the more treatment you have, it indicates to them that you are suffering more and you are going through a lot more pain because you keep receiving treatment. But yeah, most of these insurance companies have software. Different insurance companies use different softwares, and a lot of these adjusters, they utilize it. So when you send out your settlement proposal letter and you send them your medical records, your bills, and your pay stubs, it all gets filtered through the software, and then the adjuster will get a number that pops up in their screen and say, this is what you need to offer. And the first offer is usually always a low offer. It's always usually a low ball offer. And that gives room to negotiate. And depending on how low that offer is, at that point, we would decide whether we want to continue the negotiations process, or we'll say, you know what, it's not even worth going back and forth. We just need to sue this person because their insurance company is not being fair to us.
A lot of people hesitate to make that call. They're not sure if their case is big enough. The State Bar of California and the San Bernardino County Bar Association both offer referral services, but at what point should someone consider hiring a lawyer to help with an Inland Empire car accident compensation claim?
There are situations where, number one, the insurance company is asking you to give them a recorded statement. And this is not the typical one where they're saying all calls are being recorded for training purposes. Not that one. It's pretty formal. They'll say, okay, this is a recorded statement. I'm going to start the recording. This is this date, this time. So if you start hearing that, just hang up. It's okay. You don't have to be nice. You don't have to actually comply. Just hang up, call an attorney. Number two, if you think your injuries may be serious and it may require more than one visit to the doctor, let's say you have ongoing medical treatment, whether with your PCP or a specialist or at the hospital or a chiropractor, you need time off work, then I think you should be calling an attorney. If there's a chance, and we talked about a little bit this earlier, but if after the accident you're trying to talk to the other driver and they seem to be combative, or they seem to say, why did you do that? Or you're the one that did this, or what were you thinking? And it sounds like they're trying to put you at fault. Then in a situation like that, before talking to anybody, I would say call an attorney. And another time is, if a lot of times these insurance companies, they like to throw numbers at you right at the beginning of the case, right at the beginning of the claim when it's opening, because you're still in a state of not necessarily shock, but everything is fresh and everything is very overwhelming. You're just getting medical treatment. Your car's probably totaled. You don't know what's going on with your car situation. You don't even know where it's at. So you're in a high stress situation. And usually those are the times where the insurance companies will try to throw a little money at you. And it makes you kind of feel like, oh, okay, yes, okay, I'll take it. And they have you sign an agreement. They give you the money. And next thing you know, you just signed away all your rights to any future compensation. So if they try to throw any money at you right from the start, I would say before you do anything, sign anything, say anything, just say, okay, thank you. Let me think about it. Hang up, call an attorney, make sure that offer is the right number. And sometimes it is. Most of the time it's not, but sometimes it is. And then I would say, don't be scared to call an attorney at any point in time. Consultations, if it's a personal injury attorney, it's usually free. So I would say just call the attorney. It doesn't hurt to ask whether your case is big or small. An attorney, even if that attorney turns you down, don't be sad about it and say, oh, okay, so I don't have a case. Call different attorneys, because some attorneys, maybe they only take catastrophic cases. Maybe some attorneys, I always say, if you put 10 attorneys in one room and ask them one question, they'll all have 10 different answers. So different attorneys see cases in a different way, and some people might not want your case, or they don't have the resources, but some other attorney might say, you know what, I like this case. So don't be discouraged, call around. It's going to be all free to talk to them. The only annoying part is you'll probably have to regurgitate and repeat everything that had happened, because they'll probably all ask you the same questions. And then if you are ever involved in an accident with a commercial truck, call an attorney quickly. And the reasoning behind that is going to be, a lot of these commercial trucks have footage. And if they have footage, you want to send out what's called a preservation letter to make sure they do not destroy that footage, and to make sure they don't let that footage loop over in whatever SD card they may have. And most people don't know how, but a lot of attorneys will. They'll know how to get the information of the company. You can't just give that preservation letter to anybody at the company. You have to find it on the Secretary of State. You have to find the agent for service of process, and you have to mail it to that particular person at that particular address. So we want to make sure that's done within 7 days. So those are typical situations where you should be looking to hire an attorney.
That's really great advice. And then beyond the basics of like photos and police report, there is a lot of evidence that most people never think to collect. The IE freeway system is heavily monitored by cameras. And from a legal perspective, what kind of evidence is most important when someone files a car accident injury claim in the Inland Empire?
Anything in writing, any kind of video, photo evidence, anything that you can present outside of your own mouth is good. So police reports, medical records, any kind of footage of the accident, any kind of footage of your injuries, whether that be video footage, recording, photos. If you have swelling on one limb compared to the other, a lot of times when you take a picture of that one limb, it might not show the swelling because they have nothing to compare it to. So you can't really tell if it's swollen or not. So if you have swelling on one limb and not the other, I always recommend to have a picture of both of the limbs side by side, so you can see that one is clearly swollen compared to the other one. And witness statements, if there's anybody who's stuck around, I know it's hard, and especially during that time, you're not really think about it because you're so distraught from the accident. But if there's anybody that you notice that is lingering around, grab their contact information, because a lot of times they can't stay there for long. So even if you don't know what the heck they're going to say or what they even know, just grab it. You could figure that out later, or have somebody nearby grab it for you. And then the attorneys will typically hire a private investigator to go find out what they know. And then, yeah, any kind of digital evidence when it comes to cell phone records, dash cam footage. Sometimes GPS data is actually helpful too, to show you what route you were going, especially in a lane change situation. It can show your intention if you were intending on changing lanes, because if the other side is trying to say you change into their lane going left when you were about to exit right, then it helps you prove that you weren't trying to go left, you were trying to go right, things like that. And the EDR, the black box data from your car.
And when a case goes to trial in IE courts, the jury is the ultimate decision maker. The American Bar Association has studied jury verdict trends, and some patterns are clear in California. Do juries in San Bernardino and Riverside counties tend to award higher compensation for certain types of crashes or injuries?
Yes, I would say in San Bernardino, Riverside, or any county, any jury in general, is they believe what they see. So if you have burns, if you're missing a limb, if you have scarring, it's a visible injury that they can see, and they can understand your pain and suffering based off of what they are seeing has happened to you. As opposed to if it's all internal, then the only thing that you can give the jury is going to be your experience, your day-to-day, explaining to them your struggles, but there's nothing for them to see those struggles. So yeah, I would say things that they can see, there's higher jury verdicts for things of that nature. And then depending on the photos of the car crash, how severe the car crash is in and of itself, the stronger the crash, the more damage the car has sustained, the jury will feel like, oh, yeah, if I was in that car, I'd probably be hurt too. That's a big crash. I can see somebody being hurt. But the smaller the crash, now it becomes a question in the jury's head. Some juries, they're going to be pretty turned off by it. They're like, there's no way you would have been hurt, which is usually what the insurance companies like to do. They like to show those photos if you have a low damage, to show that there should be no recovery, because there's no way you could have been hurt with a fender bender of a scratch or something like that. And of course, TBI, that's the newer trend. They do award higher dollar amounts for an effect to your cognitive abilities, because that does affect who, in essence, who you are as a person.
The negotiation phase is where most car accident cases are won or lost. The insurance company makes an offer, and the question is whether to take it, counter it, or walk away and file a lawsuit. What strategies do California lawyers use to negotiate better accident settlements?
The first thing that we do is send out what's called a demand letter, and it is a roadmap and a summary of the case and your injuries to the adjuster, so they can see a snippet of it and understand your picture better, easier version, user-friendly way. So the easier you can make it on the adjuster, the better it is for them to put a value on your case. And then, of course, never accept the first offer. The first offer is always a lowball offer. It's never the final offer. They always give you an offer that they can negotiate off of. They're never going to give you a number that they can't give you anymore, unless it is the policy limits. If it is the policy limits, then they cannot give you any more than what they have available. But that first number, if it's not the policy limits, they're always giving themselves room, wiggle room, to be able to negotiate. So never accept the first offer. And I would say the last leverage, and you kind of need an attorney for this, is going to be a bad faith leverage. And that is sometimes, especially Tesla these days, but sometimes the insurance companies, they're unreasonable, unresponsive, and not giving you the time of day. It's usually due to a system failure on their end. It's usually due to short staff, or something's wrong on their end and they just can't do things right. And in a situation like that, you have what's called the California Department of Insurance, and you can look that up on Google, and you can file a complaint against that insurance company and fill in the information, and you tell the Department of Insurance, they'll give you a section where you can fill in what you want from them. And we do that quite a bit ourselves as well. And so a lot of times when you do that, now that adjuster and that insurance company gets a ding. They get a mark, a bad mark. And it doesn't do much, but when those add up, then that's when the full-blown investigations happen. But anytime that ding happens, that adjuster is now being looked under a microscope. And so now they have to be make sure that they're taking care of your claim properly. So that can help move things along. And if that isn't working and you end up taking the case to trial and you win, you can actually open up the policy. That's another thing, but usually an attorney is involved and they will go after the insurance company for the rest of that money.
A lot of people hear denied and think it's over, and it's not. The California Department of Insurance oversees insurer behavior, and the Superior Court of California, County of San Bernardino, or Superior Court of California, County of Riverside provides a path forward. If an insurance company denies a car accident claim, what legal options does the victim still have in California?
So there's a couple of denials that can happen. Number one is going to be a denial in coverage. Sometimes these adjusters, they get a little lazy and they'll just say coverage or liability is denied, but they don't explain why and how. And by law, under the California Department of Insurance code, they are required to tell you why. Because if you know why something is being denied and you have evidence that could prove otherwise, or you can provide help in that aspect of that denial reason, then you should have that ability to say, hey, I noticed that you denied this claim because XYZ, but I actually have evidence ABC to prove otherwise. And a lot of times if they give you a blanket denial and doesn't say why, the easiest thing to, and they have to do it in writing, but the easiest thing to do is respond to them and say, hey, I received this letter, please explain why. And if you don't get a response, call them. If they give you an explanation over the phone, make sure you confirm that in writing. And then the other denial that can happen is going to be a denial of bodily injury claim. And this is the ones that we see the most, the ones that we face the most. And that's usually the denial of your injury claim due to a minor impact. So let's say what we were talking about earlier when the juries look at photos of a head-on collision or a really big damage where a car is totaled. It's easier in a situation like that for the jury to believe that you're hurt. But in a small fender bender where you have less than $1,000 worth of property damage repairs, it's just a scratch or a scrape or a little dent here. A lot of times the insurance companies will deny the bodily injury claim altogether. They'll send you a letter and it'll usually say something like, due to the nature of the impact, we are denying the bodily injury claim. And it's fine. Sometimes my staff, they'll come to me, they'll be like, what do we do? And I'm like, you just ignore it. You just move on. If our client says they're hurt, they need treatment, I don't care what the pictures look like. If they're hurt, then that's the way it is. So in a situation like that, you would just file a lawsuit and you would get the compensation that way.
Deborah, this has been incredibly valuable. We covered both sides of car accident law in one episode, the type of crashes that happen on I-10 or I-15 and across San Bernardino County and Riverside County, how each one affects liability, and then the types of injuries those crashes cause, and how each one drives the value of compensation claim. For someone listening right now who has been in any type of car accident in the Inland Empire and is dealing with any type of injury, what is one thing you want them to remember?
One thing to remember would be call an attorney. I feel like I say this in every episode, but just call an attorney because they do this thing for a living, right? They do this, they breathe on it in and out. And so whatever information you think you know, amplify that, and they can see so many different possibilities. So it's always better to call and talk to them to see what your options are. Then you can take that educational information and decide whether you want to hire it or you go on your own and and do it on your own. But at least you should know what your rights are.
And if someone wants to talk to you about their car accident and their injuries, what is the best way to reach Empire Law?
We have our phone number. You can call us 951-456-3891, or you can email us at info@empire, ATTY, that's short for attorney, A, T as in Tom, T as in Tom, Y as in yellow.com. And then I think if you go on our website, there's also an inquiry form you can fill out. And I think on our Google business page, there's actually a texting feature too. If you don't feel comfortable talking on the phone, you can text us as well.
And that first consultation is free, right?
Yes.
All right. If you have been in a car accident anywhere in the Inland Empire, San Bernardino County, or Riverside County, and you are not sure what to do next, make that call. You can find Empire Law at www.inlandinjury.com or call them directly at 951-456-3891. Thank you for watching, and we will see you on the next episode of Empire Law.